India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news, biggest and most significant hearings and judgments of the day. We also bring you the details of court proceedings. Before we begin, here's the headlines. Supreme Court restricts Shapoorji Pallonji Mistry Group from raising capital using Tata Sons Shares, also tells to maintain status quo on the shares. Supreme Court asks CBSE to declare results of a compartment exam as soon as possible, says ensures students get admission in the current academic year. The Andhra Pradesh government has moved the Supreme Court, assailing the gag order passed by the Andhra Pradesh High Court. Matter relates to an FIR registered against a former Advocate General and others. The Delhi High Court has stayed the order of Delhi government dated 12 September whereby private hospitals in Delhi were directed to reserve 80% beds in ICU for COVID-19 patients.
India Legal presents Courts Roundup.
The Supreme Court ordered an status quo on the transfer or pleading of Tata Sons Shares by Shapoorji Pallonji Mistry Group companies, ruling in favor of Tata Group. Order restricts the SP Mistry Group from transferring or pledging Tata shares for the time being. The top court said it would take up the matter for hearing of final arguments on 28th of October, directing the parties to maintain status quo till then. The Supreme Court has restrained Cyrus Ministry Shapoorji Pallonji Group from pledging any of its shares in Tata Sons for raising funds. The company has also been directed to maintain status quo and not to take any action as regards to the share already pledged. The bench of Chief Justice of India S.A. Bobde and Justices A.S. Bopana and V. Ramasubramanian passed an order to this effect while hearing an application filed by Tata Sons challenging SP Group's move to pledge its shares in Tata Sons for raising monies. This application was filed by the Tata Group after the SP Group proceeded to enter into an agreement with a Canada-based company to raise monies to turn off 3,750 crore rupees by pledging its Tata Sons share. Tata opposed this move on the ground that the Articles of Association bars the SP Group from transferring the shares without first giving Tata the right of first refusal. Appearing for Tata, senior counsel Harish Salve told the court that if SP Group wishes to sell the shares, Tata is willing to buy them. However, they have chosen to hold on to shares and instead pledge them for raising funds. It was further argued by Salve and senior counsel Abhishek Manu Singhvi that the shares could not have been pledged. This point, however, was contested by senior counsel Aryama Sundaram. On behalf of Cyrus Investment, he said that the Articles of Association bars the transfer of shares and not their pledging. CJI Bobde noted that it has been held on various occasions that pledging is in fact a limited transfer itself. The bench also noted that the matter needs to be heard at length for final disposal and proposed to place the case for final hearing after 4 weeks. Senior advocate Janak Dwarkadas, appearing for Cyrus Mistry along with Sundaram, argued that the restructuring of the company was scheduled shortly and that the company had to disburse salaries of a number of its employees and migrant workers. However, both sides ultimately agreed for the matter to be heard after 4 weeks while requesting for status quo. The Supreme Court proceeded to direct for status quo to be maintained on the aspect of transfer and pledging of shares by SP Group. It added that the SP Group ought not proceed further or take action on the shares already pledged thus far. The case will be heard next on October 28th. This application was filed by Tata Group at a time when the appeals by its chairman, Emeritus Ratan Tata, and various other Tata companies against the NCLAT's December 2019 judgment remained pending before the Supreme Court. The cross-appeal filed by Mistry against the NCLAT's ruling of December 2019 is also yet to be heard. Bureau Report. Supreme Court has asked CBSE to declare results of compartment exam as soon as possible and coordinate with UGC to ensure that students passing out in the exam gets admission in current academic year. In the plea seeking extension of college admission deadlines in the wake of the delay Central Board of Secondary Education compartment exams, the Supreme Court has directed the University Grant Commission to not release the academic calendar till September 24th. UGC will inform the court about the declaration of the compartment exam results by then. The matter was heard today by bench of Justices A.M. Khanvilkar and Sanjeev Khanna. Senior advocate Vivek Tankha, appearing for the petitioner, contended that the compartment exams start from today and end on September 29th. Thus, if admission to colleges are over by the time the results are announced, the students giving these exams would lose out on the opportunity to get admitted for this academic year. On hearing this submission, Justice Khanvilkar said to the UGC, appearing for CBSE, Advocate Rupesh Kumar submitted that since the papers needed to be checked in 16 regional centres, it would take 3 to 4 weeks to declare the results. The case will now be heard again on 24th of September, when the UGC is likely to inform the court when would it declare the result of the compartment exams. The Andhra Pradesh government has moved the Supreme Court assailing the gags order passed by Andhra Pradesh High Court in relation to an FIR registered against a former Advocate General and others. The High Court had also stayed the investigation in relation to the Amravati land scam case, in which the FIR registered by the state's Anti-Corruption Bureau named daughters of a sitting Supreme Court judge. The Jagan Mohan Reddy government has mounted a challenge against this order, primarily stating that the order came to be passed in relation to an FIR, which itself was not questioned. Moreover, while only one petitioner had moved the High Court seeking relief in terms of protection from coercive action and bar of media reportage, the order passed by the High Court extends the relief to all the other accused persons as well. The former Advocate General of the state had moved the High Court on September 14 on the grounds that he apprehended coercive steps against him by the state missionary. However, the FIR pursuant to which the Advocate General's plea was filed in the High Court was registered 1 day later on the morning of September 15th. In this effect, rendered the petition infructuous, the state government contends the relief granted by the High Court is wholly perverse. The YSRCP government says in its petition, it is averred that the petition should not have been entertained by the High Court at a time when the FIR was not even registered. The High Court also proceeded to pass direction without examining the contents of the FIR, which on bare perusal reflects that a massive scam has taken place. The Supreme Court has accepted the settlement reached between the novelist M.T. Vasudevan Nair and director V.A. Srikumar in connection with the making of a movie Randamuzam. As per the settlement term, the director would hand over the script both in Malayalam and English in typewritten and electronic forms to M.T. Vasudevan Nair for the movie to be made of the said novel written by him. The author would pay him the sum of 1,25,000 rupees. Famous Malayalam novelist Nair entered into an agreement with the Earth and Air Films Private Limited to produce a motion picture in Malayalam, English and Hindi on the basis of novel. As the latter failed to pay the entire consideration, Nair filed a suit was a declaration that MOU and agreement entered into between the plaintiff and defendants to terminated, and the defendants were to restrain by a decree of permanent prohibitory injunction from making use of MOU and agreement, and further for a decree of mandatory injunction to the defendants return the English and Malayalam script of Randa Muzam in typewritten and electronic format. We are now joined by Devanshi. Devanshi, could you brief us about today's court proceedings?
In this case, Honorable Court has disposed of the SLP as withdrawn since the dispute has been settled and instructed parties that they shall abide by the settlement. As per the settlement norms, the director would hand over the script both in Malayalam and English in typewritten and electronic form to M.T. Vasudevan Nair for the movie to be made of the novel, and the author would pay back the sum of rupees 1 crore and 25 lakh.
Thank you for the update, Devanshi. Moving on. Delhi High Court has given 8 weeks to the Telecom Regulatory Authority of India to take some action on the show cause notices issued to entities to show progress made in ensuing compliance with the Telecom Commercial Communication Customer Preference Regulation 2018. The division bench of Chief Justice D.N. Patel and Justice Pratik Jalan has asked the regulatory authority to adjudicate upon at least 1 or 2 show cause notices issued for non-compliance before the next date of hearing. The court has come in a plea moved by Paytm seeking a direction to be issued to TRAI as well as various telecom operators to ensure compliance with the TCCCPR regulation. It is the case of the petitioner that non-compliance with the guidance have led to rise in the case of unsolicited commercial calls and SMS sent to customers to commit online fraud and phishing. The court further informed TRAI that it does not accept the body to investigate frauds. Appearing for one of the telecom, senior advocate Dayan Krishnan argued that a deadline is already in place beyond which unregistered entities can't operate. While granting time to TRAI to submit an affidavit to show action taken against some entities, the court noted that it accepts the regulatory body to adjudicate on the show cause notices issued to some of the entities for non-compliance. The Delhi High Court has stayed the order of the Delhi government dated 12 September, whereby private hospitals in Delhi were directed to reserve 80% of beds in ICU for COVID-19 patients. While staying the orders, the court said the single bench of Justice Naveen Chawla has adjourned the hearing on merits till October 16. Filed by Association of Healthcare Providers, the petition challenges the order of the Delhi government on the ground that no prior consultation was held with private hospitals to ascertain the demand-supply situation of critical care beds. It is further argued that ignoring the needs of other severely sick patients requiring critical care and ICU management at this private hospital is gross injustice. Reserving 80% of beds in ICU will deny urgent care to seriously ill patients requiring vital surgical intervention and intensive care, the petition stated. While citing that other states who are similarly situated have not passed such an order, the petitioner has argued that the order to reserve 80% of ICU for COVID patients over and above beds already reserved for them violates fundamental right to access medical facilities of other critically ill patients. The Delhi High Court today set aside the ex parte interim injunction order restraining the publication of a book on Asaram Bapu titled Gunning for the Godman, the True Story Behind Asaram Bapu's Conviction. The order was pronounced by a single judge bench of Justice Najmi Waziri in HarperCollins appeal against the injunction order passed by a district court in a suit preferred by the co-convict in the Asaram Bapu rape case, Sanchita. The court directed that already printed copies of the book be sold along with a flyer clarifying that the book is based on the judgment of a trial court which is under appeal. For online sale, the disclaimer should be given electronically, the court added. Seeking a vacation of the stay order, HarperCollins had contended that pre-publication censorship ought to be done very cautiously and that there was no occasion for a same in the present case. Sanchita, on the other hand, argued that her right to reputation and fair trial ought to be balanced with the right under Article 19(1)(a) of the Constitution. Stating that the appeal against the conviction was still pending, it was claimed that there was a continuation of trial and irreparable injury would be caused if the publication of the book was allowed. The book Gunning for the Godman, the True Story Behind Asaram Bapu's Conviction is authored by Ajay Lamba, Additional Commissioner of Police, Jaipur, and Sanjeev Mathur, and was scheduled to be released on 5th of September this year. The Court of Additional District Judge has stayed the publication of the book on the ground that the appeal against the conviction in the rape case was sub judice before the Rajasthan High Court. The Guwahati High Court recently reiterated the position of law that judicial officers are protected from legal action, civil or criminal, in respect of orders passed and other acts done in the course of their judicial functioning. Interestingly, the petitioner in this case had not only personally pleaded the judicial officer who passed an adverse order against him, but also the High Court and the Registrar General of the High Court. These provisions protect judicial officers and judges from being criminally prosecuted or sued under civil laws for acts done in their judicial capacity. While the former provision protects judicial acts done in good faith, the latter is an absolute protection for acts done by judges in the course of their official or judicial duties. In view of the same, the case moved against the judicial officer and others was dismissed with cost of 10,000 rupees. As the petitioner was a police officer, the Chief Justice ordered that the cost be recovered from his salary. The writ petition before the High Court sought a quash of two orders passed by a sub-divisional judicial magistrate. A number of students from the Chanakya National Law University, Patna, have approached the Patna High Court seeking its intervention for the reduction of fees payable amid the COVID-19 pandemic. The High Court has granted a week's time to serve the registrar, CNLU. The matter will be next heard on September 28. The petition was filed after receiving no response to the letters written to the Vice-Chancellor on August 10th and Chancellor on 25th of August. Aggravated by the inaction and opaque retort from the university on the issue, the students have expressed their concern with the fees charged under the heads of facilities fee and library fee. The facilities fee amount to about 15,000 rupees for fifth-year students of the batch 2016-2021. Additionally, a library fee to the tune of 5,000 is being charged from students of all batches. The petitioner's case in that none of the university facilities have been used in the recent months since CNLU has remained closed from March 15 this year onwards on view of COVID-19 pandemic. The petitioners have requested for a pro rata deduction of the mess charges, annual additional room rent and of the facilities fee from the previous payment cycle, since the facilities were not utilized from March 15 onwards. The Karnataka High Court asked the Court Registrar General to file a suo motu plea regarding the disposal of pending criminal cases against MLAs and MPs in the wake of Supreme Court's recent direction. A division bench of Chief Justice Abhay Oka and Justice Ashok S. Kinagi has issued the direction in consideration of the Apex Court direction, asking the Chief Justice of High Courts to formulate an action plan for disposal of criminal cases pending against MPs and MLAs. The suo motu petition will be heard on 23rd of September, where the Advocate General will either represent the state or nominate the Additional Advocate General. Amicus Curiae Senior Advocate Aditya Sondhe will assist the court. The Apex Court last week passed a slew of direction to the Chief Justices of every High Court in order to ensure expeditious disposal of pending criminal cases against the sitting former lawmakers. The Amicus Curiae had pointed out the various reasons behind this backlog of pending criminal cases. Solicitor General Tushar Mehta had assured the court that all pending cases which have been stayed by the High Court must be concluded within a time-bound manner. Actor Kangana Ranaut has filed a rejoinder before the Bombay High Court, refuting the Greater Mumbai Municipal Corporation averment that the renovation made to her bungalow were made illegally. Pertinently, she has stated that her neighbour designer Manish Malhotra was issued a similar notice in respect of his property, but that he was given a 7-day period to respond. Using this instance, she reasserted that the corporation action were a counterblast to her statement against the state government and her remark on the death of actor Sushant Singh Rajput. She has categorically denied the charges levelled against her by the corporation, stating that the charges are an attempt to cover up her ex officio illegal acts. She has also claimed that the corporation has been trying to cover up the discrepancies in the document produced, partially with regard to the time at which the FIR was filed. She had earlier also pointed out in her amended writ petition that the FIR specified the date erroneously on September 7 this year. While hearing a PIL against Deputy Collector Margau's order making uses of Arogya Setu app mandatory for entering the old collector building at Margao, the High Court of Bombay at Goa asked the state government to file an affidavit indicating that uses of the said app is no longer mandatory in light of a statement made by the Advocate General of Goa, Devidas Pangam. To that effect, Division Bench of Justice M.S. Sonang and Justice M.S. Jawalkar heard the PIL filed by activist Sudip Dalvi. Advocate Shawand Anand appeared on behalf of the petitioner along with Advocate Srinivas Khalab and Chintan Nirala. At the outset, Advocate Anand contended that the said app seeks access to personal details like contacts and citing the decision of a 9-judge bench of the Supreme Court, which stated that it has to fulfill and must meet the threefold requirement. 1. Existence of the law. 2. Must serve a legitimate state aim, and 3. Proportionality. And after having a look at the communication, Justice Sonang noted that this was different from what is being submitted by the AG. They had made it more dangerous. Advocate Anand tried to intervene. However, Justice Sonang asked AG Devidas, the uses of the said app is not mandatory. Is that the position? Yes, the AG replied. So thereafter, court had asked the state to file an affidavit in this regard and kept the matter for hearing on 6th of October. An affidavit is to be filed indicating that uses of Arogya Setu app is no longer mandatory, the court recorded in the order. Advocate Anand said that he wanted to file a reply in the matter if the state is filing an affidavit. That's it for Courts Roundup today. That if for tuning in, and keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.